Okay, I think we're all here. Good evening. This is the August 13th special meeting of the Santa Monica Rent Control Board, which we are conducting virtually in light of COVID-19 and the effort to reduce the spread. May we have a roll call, please?
Yes. Commissioner Duran.
Yes, here.
Commissioner Terosas.
Here.
Commissioner Foster.
I'm here.
Commissioner Salton.
Here.
And Chair Phyllis.
Here.
All members present.
Great. Okay, next item on the agenda is approval of the minutes. Chair will entertain a motion to approve the minutes from our July 9, 2020 meeting. There's no motion.
I move to approve the minutes.
Commissioner Terosas moved.
Second.
Commissioner Foster seconded. Can we have a roll call vote, please?
Yes. Commissioner Salton.
Yes.
Commissioner Terosas.
Yes.
Commissioner Duran.
Yes.
Commissioner Foster.
Yes.
And Chair Phyllis.
Yes.
Motion carries.
Next item on the agenda is special agenda items. This is the time where we allow for announcements pertaining to the Rent Control Board. Do we have any special agenda items, Executive Director Condon?
Yes, good evening, Commissioners. I have a few announcements this evening. I wanted to update you on the collection of the registration fee. As of the due date last Monday, we had collected, or the previous Monday, we had collected approximately 92% of the fees. For those properties where the owners had not paid the fees, we have applied the 4% penalty and sent the bills out. Hopefully we'll be receiving more of those payments in the next week or so. This year we did have approximately 30% of the payments paid online, either with credit cards or e-checks. That was about a 10% increase over last year, so we were happy to see that. We're moving in the right direction in terms of electronic use and communications. And then I wanted just to say that the Rent Control Agency is open for business. Just in case there's any question about that, we are fully open for business. Our public information team has helped more than 5,000 of our community members since March. We're holding hearings by video conference and doing mediations by video conference. So we're carrying on business as usual in these very unusual times. I also wanted to mention that the city's eviction moratorium lasts through September. And we want to be sure that our neighbors will be able to stay in their homes. So we are helping get out the word about the various rental assistance programs that are being made available. The city, as you know, had a rental assistance application period. They got about 1,100 applications by people who have been impacted by COVID-19 financially. And they expect to be able to help approximately 300 households payment of their October, November, and December rents. We also are helping get the word out about the county's rental assistance program. That will be starting, the application period starts this coming Monday, and people can apply online at 211la.org/LA County/rent relief. Or if people don't have computers, they can call 211 between 8 a.m. and 8 p.m. We've helped to get the word out by distributing it to our email list, and the city has issued several announcements over today and yesterday, and I imagine they will continue to be doing that. And so that's what I have this evening in terms of announcements.
Tracy?
Yes.
Could you please repeat for the public the dates for the city program and the dates for the county program? Because they're both. And can people apply for both in case they don't get approved for one? Can they get the other? Can they get both?
Yes. The city's program is to pay future rent. So if somebody is selected through that lottery, they will be able to get up to $5,000 to assist them with future rent. So that would be October, November, or December. The county program can be used for back rent or for future rent. So people who can income qualify would be eligible for both programs. The city's program is closed, so there's no longer an opportunity to submit an application for that. But as I said, the county's program starts on Monday, the application period.
Thank you. I just think this is huge because this, if certain legislation passes, this will turn into consumer debt, and we don't want our renters across the LA region to be burdened with that consumer debt as well, leading to future garnishments, et cetera. So at the end of the day, the best possible outcome is for the landlords to eventually get the back rent paid for with federal CARES Act money. And that's what we're seeing here with the county money. And I'm hopeful that that expands and continues to reach everyone who needs it. Thanks for the information.
Yeah.
And if I could add one, I was hoping to add one thing to the county program. To add to what Tracy said is that tenants are potentially eligible for up to $10,000 worth of rental assistance, depending on their income and, sort of what it's going to be prioritized based on zip code. But it's a relatively generous program compared to some of the other programs we've seen. So low-income tenants who are struggling to pay rent in Santa Monica due to anything that could be related to COVID should absolutely apply for this LA County program.
Yeah, and if I could just add as well, there are income restrictions clearly, but I really think everyone should apply, and I actually think landlords should inform all of their tenants, because if you're a landlord and you're concerned about staying in business, the best thing that we can all do is not only have our tenants get their rent paid, but get the money to the landlords so that we can all stay in business and stay housed. And yes, it's a $100 million program. We think that it's probably the most generous program, and I just encourage everyone to apply. Additionally, Tracy, I was wondering if you wouldn't mind repeating our website, the Santa Monica Rent Control Board website, because I do want people to know I think all of our services are virtual now. So can you just repeat our website for the public?
Yes, our website is smgov.net/rent control.
Thanks. And then also, I believe we are on Facebook. Should people want to follow us for very current updates, that I think is important as well.
Yes, thank you.
So thanks for all you're doing, and thanks for trying to get the word out on all of this. Really, really appreciate it.
And thank you to Mr. Costello and his team for helping get the word out as well. Thank you.
Yes, of course.
Okay, any other announcements? Okay, looks like we have none. Next item on the agenda is public comment. This is the opportunity for members of the public to speak to the board on any matter of general interest to the community that's within the board's subject matter jurisdiction. State law prohibits the board from taking any action on items not listed on the agenda. Lonnie, am I correct that we don't have any requests for public comment tonight?
That's correct.
Great. Next item on the agenda is item 10A, an appeal, N0276, 2502 Euclid Street, Unit 1226, appellant Mr. George Poptis, trustee of Poptis Trust. The landlord appeals the hearing officer's decision denying the landlord's petition by tenants not in occupancy. Maybe we have a staff report.
Good evening, commissioners. Bahriel Ibrahim moved into Unit 1226 at this 2502 Euclid Street in 1994, and his wife Teresa Mack joined him in 2009. In 2013, Mr. Ibrahim was hired by an investment firm in San Francisco, and he bought a duplex in Sausalito, and he moved into it so that he could commute to work from there. He also regularly visited his wife in Santa Monica, who was still working and living here. In 2017, Ms. Mack stopped working, and she moved to the Bay Area to live with her husband. Since then, the couple estimate that they visit their Santa Monica apartment about 3 to 5 days every month. Because they've been largely absent from their apartment for 3 years, their landlord petitioned the board to find them as tenants not in occupancy and to adjust their rents based on market rents. Mr. Ibrahim and Ms. Mack do not dispute that they have mainly lived in Sausalito for the last 3 years, but Mr. Ibrahim argues that he intended to move back to Santa Monica after his employment contract terminated in November 2019, and that they were seeking contractors to prepare their Sausalito home for re-rental, and then the state lockdown measures went into effect and put a halt to that. The hearing officer denied Mr. Potts' petition because she found Mr. Ibrahim and Ms. Mack's absence to be an, quote, excused temporary absence due to travel necessitated by employment, and that the pandemic lockdown measures disrupted their efforts to return. Mr. Potts has appealed the decision, and he argues first that having 10 days to submit an appeal was procedurally unfair, and that substantively he argues that the record doesn't support the hearing officer's decision. First, as to the procedural argument, the hearing officer here issued her decision 6 weeks after the record closed, and the board's regulation then gives the parties 10 days to file an appeal. Although Mr. Potts argues that this is procedurally unfair, he did in fact file his appeal in a timely manner, and he set forth in detail the reasons why he believed the record did not support the decision. 10 days is a standard time period for filing appeals in administrative decisions, and a party can file a late appeal if they can show that they have good cause for doing so. Here, Mr. Potts didn't even need to do that. There is no basis to conclude that having 10 days to file his appeal was procedurally unfair. But Mr. Potts' substantive arguments in his appeal have merit. The record is clear that Sausalito has been the tenant's residence since 2017, their principal residence. From testimony by all the parties, from DMV records, mailing addresses, they even filed a homeowner's exemption for the Sausalito home in which they'd have to represent that that home was their domicile to the state. In July of 2019, Mr. Ibrahim's employer, his contract would not be renewed, and when it terminated in November 2019. Despite having 4 months' notice, the couple didn't show that they used that time to prepare for their return to Santa Monica, even though they insist that that was their intent to do so. Even by March 2020, 9 months after receiving their notice of employment termination, they had not moved back to Santa Monica when the pandemic lockdown measures went into effect. In fact, they still had not secured the contractors to prepare their Sausalito home for rental at that point. This gives some reason to doubt the veracity of Mr. Ibrahim's assertion that he and his wife actually were preparing to return to Santa Monica, much less that their return was imminent. But even if they did intend truly to return to Santa Monica at the time of the lockdown, that does not make Santa Monica their principal residence. That they principally resided in Sausalito does not necessarily preclude Santa Monica from being their usual residence of because the board's regulation excuses certain extended absences, such as for military service, medical treatment, or, as in this case, for reasonable temporary or seasonal periods of absence, such as travel necessitated by employment. This is the basis upon which the hearing officer denied Mr. Potts' petition, but staff believes that this is a misapplication of the law to the facts here. A person who lives in a given residence and is frequently gone because she is, for example, a traveling salesperson who's only temporarily away and doesn't give up her domicile even if she's away most of the year. Also, a person who's employed locally, but whose employer sends them to fill a position in a foreign locale with the understanding that the assignment is temporary, that person hasn't given up their domicile. But neither of those are the case here. Mr. Ibrahim left his Santa Monica work that is normally local, but for a full-time position 400 miles away. It is true that he traveled extensively for work. In fact, he estimates 6 months out of the year. But he didn't travel from Santa Monica to work in Sausalito. He moved to Sausalito and then traveled to other places from there. And he lived in Sausalito to commute to a job in San Francisco. Ms. Mack didn't move to Sausalito because of travel for employment either. During the 6 months of the year that Mr. Ibrahim was away, Ms. Mack was at the Sausalito home, not in Santa Monica. Those facts are not consistent with the claim that Ms. Mack was away from Santa Monica only to be with her husband while he was in Sausalito. The couple's extended absence from Santa Monica is not the type of absence excused by the board as temporary or seasonable. One's principal residence of return is that dwelling place in which his or her habitation is fixed, wherein the person has the intention of remaining, and to which, whenever he or she is absent, the person has the intention of returning. Whatever the couple's subjective intent may have been, the objectively observable facts in the record are that they did not return to their Santa Monica apartment when they were not otherwise kept away by external forces. Staff therefore recommends that the board reverse the hearing officer's decision, find Mr. Ibrahim and Ms. Mack to be tenants not in occupancy, and to adjust their rents based on Regulation 3304, $2,435, by adopting the proposed modification to the decision's findings of fact and conclusions.
Great. Thank you. Seeing no questions for council, I will move to our speaker list. We have 4 speakers tonight in the following order. Mr. Thomas Nitty, counsel for the appellant. Mr. Poptis, the appellant, 5 minutes each, or a total of 10 minutes. And then for the tenants, Ms. Sitora Resnikoff, attorney for the tenant, and Shah Ibrahim, the tenant, also 5 minutes or 10 minutes total, 5 minutes each or 10 minutes total. We'll start with Mr. Nitty. Obviously, you've heard the staff report. Happy to hear from you.
Yes, this is Thomas Nitty. I agree with the staff report. I believe that is the proper analysis. Looking at the regulation, the test is the usual residence of return. I believe if you were to look at any random day for the past at least 3 years and figure where was the tenant returning to that evening if he wasn't otherwise out of town. And by far, the majority of those nights were Sausalito. So that is why I believe the staff report is correct. And I would like to reserve a short time for rebuttal.
Thank you, Mr. Nitty. Mr. Poptis, would you like to be heard, or would you like to be heard?
Yes, I would.
Okay.
Well, basically, the family's owned the property for many, many years. We've been in the property managed business for, like I have for 40 years. That particular building, I in fact used to live at, and we have garages in the back, so I actually use that as a base for other buildings that we manage. We pick up supplies, and we go to other buildings, store stoves, refrigerators. We frequent the building a lot, and I never, back for years, I haven't seen Mr. Abraham or his wife, and I'm at that building at least 2 or 3 times a week, coming and going, along with my normal rounds of just looking at the building, which I do on other properties we manage. But I'm there more than most buildings because of the access to the garages. And even to this day, probably, I would guess Mr. Abraham will be speaking from Sausalito. He is not at the property. And I honestly I see all my tenants, and I have not seen him there for years. So that's really what I have to say.
Thank you, Mr. Poptis. Next, we will hear from Ms. Resnikoff, attorney for the tenant.
Good evening, board members. I hope you can hear me well.
Yes.
I would like to just address the issues in order, I guess. First, I would like to state that me and my client and I are agreeable with hearing officer's decision. It was very well argued and analyzed, we believe, and for a couple of reasons. So first reason is we have to look at the language of Section 3304, which specifically addresses the issue of whether or not the tenant is a tenant in occupancy. And specific language of the statute is as follows. Occupancy as a tenant's residence does not require that the tenant be physically present in the unit at all times or continuously, that it is the tenant's usual residence of return. So it lists evidence that the unit is not the tenant's residence includes, but not limited to following factors. There are numerous factors that the hearing officer considered. And these factors shall be weighted in the light of the totality of circumstances. I think the main point that we should make that it shall be weighted in light of the totality of circumstances. I believe hearing officer's decision was exactly based on totality of circumstances. What appeal does and the staff report does, it takes the sentences out of hearing officer's findings out of context, certain sentences separately, and puts them together. And when you look at the appeal and you look at the staff report, read it, it gives you an impression that, yes, that's definitely, why would hearing officer come to this decision? But the problem here is that when she was making her decision, hearing officer, she was basing it on other circumstances and testimony that was provided, which appeal doesn't mention, and the staff report doesn't mention either. So I would like to point out those particular instances which staff report doesn't address. So specifically, when we look at hearing officer's decision, she provides very well organized and argued each point of that statute 3304, specifically whether or not another property or unit is listed as the tenant's place of residence or any motor vehicle registration, driver's license, voter registration. Staff report, I believe there's a mistake in the finding that when they discussed the DMV record, that the DMV records present that Sausalito, which is San Francisco residence, listed as a main residence, which is incorrect. There's an evidence and exhibit in the decision and during the hearing was presented that my client's ID still has a Santa Monica address. In addition to that, voter's registration in the appeal pertained that it states that the mailing address is listed as Sausalito, but it omits the main important factor that my client is still registered to vote in Santa Monica, which I think is more important. The mail forwarding issue is addressed specifically in the decision, which provides the reasoning why the mail in the first place was forwarded. My client lost a lot of important mail in Santa Monica, and the reason is because Mr. Poptis' sister, I believe, who helped him manage the property, goes into the mailboxes and empties them. So that's not only illegal, but also that's the reason why the mail was forwarded, the duration of time was forwarded to Sausalito address, and that's why voter registration was mailed to that address. In addition to that, the ID I mentioned. So the second, the third, I guess, the third section of the 3304D, it talks about utilities for the unit are billed and mailed to a different residential property, which in this case it was not. The hearing officer's decision clearly provides information in regards to what utilities were still in place. My client still, during all this time, still has cable TV, internet, active, and all listed in Santa Monica address. And those are all factors that a hearing officer had to consider when making her decision. And almost on each section, my client scored that he's still a tenant in occupancy in Santa Monica. So the number 4 is the tenant's personal possessions are not located.
That's the 5-minute mark.
Oh, that's a 5 minutes?
Ms. Resnikoff, you can keep going for 10 minutes, but this will mean that your client will have less than 5 minutes. So proceed accordingly.
Yes, thank you. Thank you. So I'll try to be brief. So there was a testimony that my client's old belongings, pictures, his kitchen, the furniture, everything was in Santa Monica. Whatever they had in Sausalito was acquired separately. So the next item, and the most important item is number 7. The tenant is absent from the unit for extended period of time other than temporary or seasonal travel necessitated by employment or education. So I believe that's the main issue that was discussed. And based on the testimony that was given, so it was determined, which is conclusive, that half of the time my client was traveling for work. So that leaves 15 days a month traveling for work. The rest of the 15 days was equally divided, or more or less equally divided, between 2 residences, Santa Monica and Sausalito. That's why when Mr. Koptis and Mr. Needy claimed that any day you take in any given year, and most likely he's not going to be in Santa Monica, that's not correct, factually incorrect. And if you even do the math, that's incorrect, because if 180 days a year, which is, a little less than half travel time, then that leaves only the other half to be in the first place. And that was divided between Santa Monica and Sausalito. That's how we come up with the 5 days, 3 to 5 days a month. And another thing I would like to point out, which is important, is that so all those statements that made in the appeal and the staff report, they're really taken out of context. So they're taken from this specific paragraph, just the 1 sentence and 2 sentences, but which is, if you read the whole decision, it's very easy to follow the hearing officer's decision and the analysis. It makes complete sense. And I just briefly would like to address the issue of if in case the tenant is not found, the tenant to be tenant in residency, I would like the board to analyze and reconsider the amount of the rent, which is $24.35 in the hearing officer's decision. And there was a testimony that this property wasn't renovated or anything was done with the property for last 26 years. And the comparable unit that was the base rent for which was provided for the basis for the decision that the rent to be increased to $24.35 was based on the comparable unit which was remodeled, the floors were refinished, repainted. So I think that to get this amount of rent, the plaintiff landlord would have to remodel the whole property. And based on that, I think it should be reduced. And another quick thing, that on the Civil Code section 827, it would require any rent increase over 10% would require a 90-day prior notice. So if that decision is made and rent is increased more than 10%, we would request the board to not to make this increase until 90 days after the proper notice is given. I'm not sure if I hope my clients still have some time left, but thank you so much for your attention.
Thank you, Ms. Resnikoff. I believe we have a question. Is Mr. Ibrahim going to speak? Actually, we have a question.
My question for her.
Yep. Commissioner Foster, go ahead.
Counselor, the one thing I haven't heard anyone address is the fact that your client took a homeowner's exemption for the Sausalito property, which states unequivocally that that has to be their primary residence. One of the biggest problems I'm having with this case is you can't have it both ways. So how would you address that fact that's in the staff report?
Sure. Thank you for bringing this to my attention. There is a specific testimony as to that. My client did state that he doesn't get involved in it. His accountant prepares his taxes, and his accountant is the one who claims all the exemption necessary. He did not even understand clearly what the home exemption meant. And I believe, based on the totality of circumstances, the hearing officer was really determined that he was very trustworthy and he was credible witness. So I believe that, that was the basis for her decision. And
you've answered my question. I don't mean to give more time. It was just that one question. Thank you so much.
I know we have other commissioners in the queue. Commissioner Trosis.
Yeah, that was my question in part, but Ms. Reznikov, you are a lawyer, is that correct?
Yes, I am.
And you're probably familiar with the provision that ignorance of the law is no excuse, is that correct?
Yes, I understand. I understand, but
your client did sign his tax return, and he did avail himself of a homeowner's exemption. I myself have filed for a homeowner's exemption. I personally had to sign it. So I would just, remind your client that just because he didn't know what he was signing, I would encourage your client to get a little bit more educated in the future.
Sure. Thank you.
Thanks.
I understand that Mr. Nitti reserved time for rebuttal, but it seems like there may be consensus among the board. Mr. Nitti, do you wish to be heard?
Oh,
yes, briefly.
Oh, I'm sorry.
Yes,
Wait,
briefly.
I'm sorry, Mr. Nitti. I believe was that Mr. Ibrahim?
Yes.
How much time, Lonnie?
Than 2 minutes.
1 hour, right here, 1 minute and 25 seconds.
Okay, 1 minute and 25 seconds, Mr. Ibrahim.
Okay. Members of the board, I've lived in Santa Monica since 1994. Thank you for hearing this case. I'm in fact calling from Santa Monica. I'd like to correct the characterization. This is a beach pad. It's 13 blocks from the beach. I can see the sea, but it's from my kitchen window. I've been living here since 1994 and was away a few times. One for work in Malaysia in 04, 07, doing some contract work. Another when I spent almost a year away taking care of my father. Santa Monica is where I got married. It's my home where I finished graduate school. It's where my personal effects are and where I consider home. I've always come home. In 2013, I got a contract offer to diligence technology companies. Initially, I rented Airbnbs and hotel rooms up to 3-4 weeks at a time. It got very expensive. SF was still getting over the financial crisis of 08, and I found it cheaper to buy than to rent or to rent hotel rooms. And we managed to find the Sausalito place for a good price. My wife had continued to live in Santa Monica till she left her work in 2017 because she decided it was better to be closer to me. The company I was working was based in San Francisco, and frequently I would work all day, get on a late afternoon or red-eye flight to go to a client site. Travel took me everywhere, East Coast, Texas, Arizona, Washington, many places, and many of the flights were from SF. Anyway, I would route flights through LAX whenever I could. If you wonder why the two-bedroom place in Santa Monica is important to me, it's because it's my home. I went to college and graduate school here. It's my center of gravity. My friends are here. It was always my intention to return.
Thank you, Mr. Ibrahim. Commissioner Trosis, you have one question, and then we'll return to the time that Mr. Nitti reserved for rebuttal.
Mr. Ibrahim, do you still own your house in Sausalito?
Yes.
And what's your intention with that house?
To rent it.
Okay, thanks.
And Mr. Ibrahim, where are you currently right now?
I'm in Santa Monica.
Great.
At your apartment?
Yes.
Okay.
At my dining table.
Got it.
Thank you. Okay, Mr. Nitti. You have, Mr. Gwynn, can you please let Mr. Nitty know how much time he has for rebuttal?
He had 4 minutes and 10 seconds yet.
Okay.
Yeah, thank you. Thomas Nitty here. I'd like to comment that the resident did not appeal the rent amount that was determined by the hearing examiner. The attorney argued for a lesser amount, but it was not, the tenant had an opportunity to file an appeal of that amount, but did not. Most importantly, the attorney for the resident argued just a few moments ago that the resident was traveling about 6 months of the year. And then she said that the other half of the year was pretty much even between Santa Monica and Sausalito. But that's exactly contrary to the testimony of the tenant. The testimony of the tenant was that he spent at most 3 to 5 days in Santa Monica during the course of those several years, 3 to 5 days each month. So if we figure that the tenant's traveling, the resident's traveling 6 months a year, and then there's 15 days of each month left over, well, it looks like it's 10 to 12 days in Sausalito and 3 to 5 in Santa Monica. Clearly, Sausalito was the usual residence of return. Thank you for the opportunity to address you.
Thank you, Mr. Nitty. Commissioner Foster, a question for Mr. Nitty, or would you like to move into discussion?
No, this is in discussion. I'm going to start with a question for staff, and then I have a couple discussion points.
Great.
Question for staff, Stephen or Haka. The rent amount, can we adjust it? Is this like other cases where we have adjusted rent decrease petitions and things like that?
No, because it is not before you on appeal.
So the attorney for the landlord was correct in his assertion that they did not avail themselves of, and they were properly noticed of an appeal process?
Yes.
How long does it, and were they noticed at their Santa Monica address or the Sausalito address, or both? Because I know sometimes you do both.
Mr. Mordezai has the file with him and is better placed to answer that question.
In other words, I know that the forwarding process, I mean, I've had my mail forwarded in the years past, and I know it can take a long time sometimes to reach. I just want to make sure. I remember from other cases we've noticed at both addresses. Was that the case here?
Correct. And we also, because of the current situation, we also sent all of the decisions by email. We go out of our way to get email from people because we know this, what's, all the difficulties right now. And so there's multiple ways in which the parties have been informed of the decision and their right to appeal, and of course this.
Okay, thank you. And I'm kind of sad about that because I do think that this is that I have to agree with the staff report and that it's a tenant, not an occupancy situation. However, I was concerned about the amount of the rent being nearly market. I mean, what was it, $40 less than for something not to have been updated for almost 3 decades, but to be only $40 less than full market is a little challenging for me, but it's a tenant's responsibility to understand the most important thing in their lives, which is their domicile and the contract that rules that domicile and your relationship with your landlord and your relationship with the city and the laws that protect that tenancy. And in this case, the Santa Monica Rent Control Charter and our city codes. It's all of our responsibility to be aware of the law, whether it's the speed limit posted on the highway or the rules of the road in navigating your tenancy and building ownership in other jurisdictions. I think when the tenant took that homeowner exemption in Sausalito, that was it. That was just it. And whether it was out of ignorance or an accident is we cannot consider that. We have to consider what meets the merits of our law, and in this type of procedure of a tenant not in occupancy proceeding, that is sort of trumping other considerations. I don't think that it did not influence me as to whether this person was testifying from Sausalito or Santa Monica tonight. That's not the, during COVID, and it's for myself, I was not even considering where the tenant was the last 4 months, or whether or not the tenant had moved forward in rehabbing their Sausalito apartments for rental. I actually subtracted that in my mind for this purpose because of COVID. I wouldn't expect contractors to be coming out and working safely inside my home, and I wouldn't be probably able to market an apartment very easily at this time. So I wasn't taking that into consideration. However, the amount of years, time, and the tax exemption, that did it for me. I am regretful that we can't adjust the rent amount and that the client didn't avail themselves of that. Last thing I'll say, staff, what about the new piece of legislation that was passed recently that says any increase over a certain amount gets 90 days? That feels very relevant to me. Can staff opine on that?
It is relevant to the conduct of the landlord and the tenant. It's not relevant to what the board does. The board adjusts the maximum allowable rents as of a particular date. This is also true with the annual general adjustment. The maximum allowable rent is adjusted as of September 1 of that year. If the landlord doesn't give proper notice, he or she can't collect it. So there are two distinct issues. One is what is the maximum amount that you could possibly charge under our law, and the second is what is the amount that you're allowed to collect under state law, which may not be as high as the maximum allowable rent because you haven't given notice. So the board doesn't need to take any kind of action to purport to enforce state law. State law is what it is. And by the board adjusting the maximum allowable rent as of the date specified in the decision, that does not in any way alleviate the landlord of the obligation to comply with state law.
And last question, why did it take 6 weeks to issue a decision? Was that COVID related, or if the decision was that within our normal time frame?
Ms. Nalabov, who's the hearings department manager, is probably a better person to answer that than I am.
Ms. Nalabov, are you having technical difficulty? Lonnie, could you assist Ms. Nalabov with her mic? Or I can probably do it.
Okay.
There we go.
Yeah, can you hear me now?
Much better.
Okay. The hearings department, COVID and no COVID, is extremely busy. The hearing officers have a lot on their plates, lots of decisions to write. And 6 weeks for a decision, you could see this was, a pretty close case with a lot of evidence to consider. 6 weeks for issuing this decision is within what we try to do. 30 to 60 days is what we generally reach for. We can't always make it. Some are issued much faster if they're very simple and the hearing officer doesn't have such a big caseload. But when they're very busy and things are taking a bit longer because of the COVID remote hearings, this was not an extraordinarily long period of time.
Okay, that's a satisfactory answer. Thank you so much.
Sure.
Thank you so much. Okay, Commissioner Torosis, and then I'll put myself in the queue after Commissioner Torosis, unless there's a motion.
Again, we've heard these tenant not in occupancy cases before. There have been long periods where the tenants were not in Santa Monica, and obviously this turns on the intent to return. And to me, I'm sorry, I literally cannot see a way around having filed a homeowner property tax exemption that there's an intent within the constraints of the law to return to Santa Monica. I also think that this was a considerably long period of time before there's any mention of even going back to Santa Monica, and COVID's really not a factor in this for me either. Again, I think this turns on intent to return, and I just don't see that here. So, obviously, I think that the tenants should ensure that the law is being followed appropriately with respect to our new 90-day notification period. But for me, I think this one is pretty clear. Thanks.
Okay, I'm in the queue. I'm prepared to move this item. I think there is consensus among the board. Honestly, I think, Mr. Ibrahim is extremely sympathetic. Obviously, he's a community member, but being a sympathetic tenant is not enough to demonstrate that you have been in occupancy as required under Regulation 3304. And anytime a tenant purchases a home and another, purchases a home period and spends a substantial amount of time there, I think you need to pay particular attention to whether it's going to become your domicile. And based on the objective evidence here, I think it is, particularly given the standard of review, which I believe is clearly erroneous. So there has to be no reasonable trier of fact could find, based on the evidence in the record, that that the hearing officer reached a correct decision based on the record. Is that right, Mr. Mordesai?
Look at factual findings, but here, the hearing officer's decision, we're disagreeing with the legal conclusions as well, and the application of the law with regards to the exemption for excused absences. So in that case, you're taking a look at this situation. If it was clearly erroneous of the hearing officer to conclude what they did, that this was somehow excused as travel for employment.
Right. I understand. So it's a less deferential standard. I think we've satisfied our obligations. I'm prepared to move the item to adopt the findings of facts and conclusions of law in the staff report. Is there a second? Commissioner Trosis?
Oh, go ahead.
I'll second. Sorry, I didn't unmute quick enough.
I don't think anyone did. Okay, we have I've moved the item. There's a second by Commissioner Trosis. No one wants to be heard on the item. May we have a roll call vote, please?
Yes, Commissioner Foster?
Yes.
Commissioner Sultan?
Yes.
Commissioner Duran?
Yes.
Commissioner Duran?
Yes. Can you hear me?
Oh, yeah. And Commissioner Trosis?
Yes.
And Chair Phyllis?
Yes.
Motion carries.
Great. So next item on the agenda is item 12A. This is the final item on the agenda, and it makes me very sad because we have long had the top rent control general counsel in the country, dare I say the world. Stephen Lewis is truly an exceptional lawyer. I've come to know him well. Even when we have disagreed, I've always been absolutely impressed by his acumen, and I don't know how anyone will even come close to filling the hole left by your retirement, which is well deserved. But the administrative item is discussion of the means by which it will recruit for a new general counsel. And I just want to personally thank Mr. Lewis. Your service to the board has been absolutely tireless. And I think that you are both an unbelievably impressive advocate and a true civil servant. And I'm just personally incredibly grateful for the opportunity to get to know you and to have worked together.
Well, thank you. It's been a privilege for me too.
All right.
Can we not accept this?
I know that I kind of want.
We do not accept.
Well, for better or for worse, this item is not really my retirement, it's the recruitment for the replacement, so.
We'll save our remarks for later, yeah.
Yes, no, I know, but we see it in the pipeline, and it's very sad. It's a sad moment for the board because I've been here now 6 years. You've been our general counsel the whole time, and honestly, the better I've gotten to know you, the more impressed I've been. I don't know how we'll do it, but I guess the next step is to discuss how we will recruit for general counsel. So, Executive Director Condon, do you want to give us some guidance there, please?
Yes, I do. And I have to agree with you, Chair Phyllis. Mr. Lewis has contributed so much to the agency, and he's been such a wonderful partner for me to work with. So I'm going to certainly feel this loss. But he will be retiring in November, and we need to start a recruitment process. So what the board has done in the past is the general counsel position and the executive director positions, the board makes that decision themselves. So what we will do is solicit applications. We will get the word out to everybody we know who works in the area of rent control and others who might be interested in the position. And then we will review the applications and select those who meet the minimum qualifications, and the board will have an opportunity to interview the people who meet the qualifications and then select from that group. In the past, when we did this, the board established a subcommittee of 2 commissioners who assisted in reviewing the applications and helped us make those initial decisions. So if the board would like to establish a subcommittee of 2 people, tonight would be the time to do that so that we could initiate the recruitment process.
I have a question. So if you are on the subcommittee, you still can, I guess the question is, how do we interview the person altogether? Are you saying the 2 people on the subcommittee are the only 2 permitted to interview the candidates, or they just do the initial screening and then send it to the full board?
The latter, what you just said. The subcommittee would be involved in reviewing the applications, but all of the board members would participate in the interviews of the candidates and participate in the decision.
I mean, I would say I'm not that I have time. No, none of us have time, but I'm definitely interested. But I'm sure others are as well. Go ahead, Commissioner Foster.
I'm definitely, and as the only I don't want to be discriminated against for the subcommittee because I'm the only non-attorney on the board. I also think it's really important how a general counsel interacts with the board in ways other than strictly legal. It also has a lot to do with making sure their attitudes and goals and an absence of politics and all of those things can play in. And I think a non-attorney such as myself could also have a lot to say about narrowing down a list. But if my fellow board members don't agree, I would be happy to step aside, and knowing that we all get to interview everyone who makes it through.
I will happily nominate Commissioner Foster. I think it is absolutely important to have a non-lawyer on the subcommittee, which means I don't see any objection to that nomination. Is there anyone else who wants to serve on the subcommittee?
I think Commissioner Trosis did.
Trosis, sorry. Your hand is very small, and and my screen, I'm having some technical difficulties, but yes. So Commissioner Trosis, Oscar and Trosis is the
I just want to be respectful. Just because I said I was interested, is anyone else also interested? Because I'm happy to also not do it. I would just say that I've done a lot of hiring in my career, and I'm happy to do this. I think, I'm very upset that that General Counsel Lewis is leaving us, but I want to make sure we have the absolute best replacement that we possibly can find. And whether that means me personally begging people, I'm not above that.
I think that that's a great idea. Do we need to vote on this, or can we just accept that Commissioner Foster and Commissioner Trosis have self-designated to serve on the subcommittee?
Whenever the board takes action, it has to do so by vote, so that there's a record supporting the action that the board took. And in this case, the board would be taking an action. That action would be the formation of a subcommittee.
All right. So,
Commissioner Braun.
I'd like to make a motion that we form a subcommittee to look into who our new general counsel will be and appoint Commissioners Trosis and Foster to lead that subcommittee as was discussed.
I happily second that. Can we have a roll call vote, please?
Yes. Commissioner Foster?
Yes.
Commissioner Drawn?
Yes.
Commissioner Sultan?
Yes.
Commissioner Trosis?
Yes.
And Chair Phyllis?
Yes.
Motion carries.
Okay, that brings us to adjournment. Is there a motion to adjourn? No one wants to leave. Okay.
I move to adjourn.
Okay.
Second.
Okay. Commissioner Trosis moved. Commissioner Duran seconded. I would like to adjourn in honor of Kamala Harris, who is the official nominee for vice president and a historic nominee for that.
Great.
I'm not sure. Counsel, is that okay? Are we allowed to do that?
Board can't appropriately do anything that is partisan, but I understand your motion to be to adjourn in honor of the historic nature of her choice, rather than the political party that she's associated with.
That is absolutely 100% correct.
Well said. Well said.
Thank you, Commissioner Lewis. Not Commissioner Lewis, General Counsel Lewis.
I'm gonna put that in my criteria. I'm making notes right now.
Okay. Do we need a roll call vote to adjourn?
Yes.
Okay.
Commissioner Trosis?
Yes.
Commissioner Foster?
Yes.
Commissioner Duran?
Yes.
Commissioner Sultan?
Yes.
And Chair Phyllis?
Yes.
And we are adjourned.
Thank you.
Thank you.
Thanks, everyone.
Good night, everyone.